the federal government's approach to the housing foreclosure crisis seems to be pretty much limited at this point to helping the banking industry.
Imagine that.
They are coming up with other schemes, sort of like the bank bailouts they've already done, to take these quote-unquote troubled assets out of the hands of the banking industry and put them into some federally guaranteed program where the government will end up paying it off.
Well, we get to pay for it.
The loss is spread among all the taxpayers. The loss is spread to the public generally instead of making the banks take the loss. What can you do? Because of the non-judicial foreclosure process, some of the things that have been done successfully in other states, where people have to go to court to go to foreclosure, have not yet, at least, been successfully tried here. One of them has to do with the fact that because all these mortgages are collateralized and packaged and spread into a 10% interest to go to this person or a 10% interest go to that person, nobody really knows who the hell owns these loans. There's a servicing agent who's collecting the money on the loan, who's probably the bank that you got the loan from, but they don't own, but they actually owned the loan for about 5 seconds after you got it. And in some states where judicial foreclosure is required, some judges have said, well, before you can proceed with this foreclosure, you've got to show me that you own the loan. Bring me the paperwork. Bring me the note. And if it's been assigned, bring me the assignments. Prove who you are. Otherwise, you don't have any standing to be in this court. And the banks are, oh, gee, it's somewhere. People have stayed in their homes. People have successfully beaten foreclosures in those situations. Theoretically, we ought to be able to do the same thing here in facing unlawful detainer, eviction cases after foreclosures. We ought to be able to say, prove who you are, prove that you own this property. It's tougher here because of the way foreclosures are done, and I'm not aware of it having successfully been done as of yet anywhere in this state. But it is something that we're looking into and something that we hope to be able to try. But our main thing is we're going to look at our main thing in foreclosure and post-foreclosure situations in trying to keep people in their homes is relying on the fact that the post-foreclosure evictions are done primarily by about 4 or 5 law firms in the state of California. There's one located in Davis, and the others are in the San Diego and Los Angeles areas. And they are all idiots. They don't know what the hell they're doing. Their only advantage is that you don't really have to know very much in order to do a post-foreclosure eviction, because there aren't any issues unless we can successfully get the courts to rely on this real party in interest, this prove you are who you say you are defense. But you do have the advantage, such as it is, that the banks now have to give you some sort of workout process, some sort of workout opportunity. The second one, the 3-month one, the law specifically says that their failure to do it is not a defense to unlawful detainer. possible that it's possible we'll be able to argue that there's a requirement to negotiate in good faith to try to do a workout. And we might be able to enjoin foreclosure sales based upon their failure to do that. But that remains to be seen because that law hasn't gone into effect yet. That's something people are looking at, and people are kind of coming up with, well, what can we do? How can we use these laws? But what we really need is to, if we're going to use the law at all, and our presentation on May Day is interesting in this context because they didn't actually abolish May Day as a holiday. They tried to steal it instead because May the 1st is now Law Day.
Sponsored by Coors.
But we are, if we're going to use the law at all, we need to pressure the legislature and the Congress to come up with more substantial protections, more of the substantial changes like they did in the 30s when they enacted the anti-deficiency laws. Now there are other extra legal avenues that can perhaps be used at all as well. Squatting is one. Returning people to their homes after they've been evicted. That's all illegal. It's all dangerous because they're trespassing, or there's a separate law that specifically makes it an offense to go back into a property after you've been evicted from it. But one of the advantages of the criminal system is that somebody charges you with a misdemeanor, you're entitled to a jury trial. And we have to put the idea in the minds of people that they should serve on juries and refuse to convict in those situations. But primarily, right now, all we really have in California is the obligation of the bank to try to negotiate a workout, or say they're trying to negotiate a workout. But usually right now, up to now, all they've really been willing to do is offer much the same thing that you can get in Chapter 13. That is, start making your current payments and make up all your past payments. And that really doesn't make sense from the standpoint of somebody who owes twice as much as the property is